Namaskar. I, Harshali Chowdhary, Additional District and Sessions Judge, come faculty member, Chandigarh Judicial Academy. Welcome you all. Today, I shall be making a presentation on the Digital Protection Data Bill 2022. Without further ado, let me start with my presentation. So with the advent of various types of technology and availability of such technology at a lesser cost, users produce tremendous volumes of personal data 24/7 by using digital device. From ordering food online to shopping, clothes, books, and other necessary items to booking tickets, appointment with doctors, etc., to digital payments, every aspect of one's life has become dependent on technology. Now, to put in a simple word, life has become dependent on two essential things: smart devices and internet access. So, it would not be out of place to mention that data is definitely has become the new oil, since the availability of data, processing it, utilizing it in formulating a perfect algorithm for technology has become very expensive for companies providing digital device services. When combined with the computational capacity of firms, this data can no doubt damage the autonomy, self-determination, freedom of choice, and privacy of the data principle. Now, looking at the existing framework, Information Technology Act 2000 as amended in 2008 no doubt has certain provisions. For example, Section 43A of the Information Technology Act requires any body corporate that possess, deals or handles sensitive personal data to maintain reasonable security practices and procedures. If negligent, shall be liable to compensate the victim. Section 72A punishes intentionally or knowingly disclosing personal information acquired for providing services under a lawful contract without the person's consent or in breach of lawful contract. Now, the government has also introduced the Information Technology Reasonable Security Practices and Procedures and Sensitive Personal Data or Information Rules 2011. It has definitions like personal information as any information relating to a natural person that can be used directly or indirectly to identify that person. That is personally identifiable information. Sensitive personal data or information is a subcategory of this information, including user names, passwords, financial information, health conditions, biometric, sexual orientation, etc. Now, IT rules states that body corporates must provide a privacy policy with clear and easy to understand practices, purposes, and types of data collected, whether personal information or sensitive personal information. Now, before collecting such information, the rules require written or email consent from the provider. The information provider must give the option to opt out of the providing personal and sensitive information before collecting it, and the option to withdraw consent at any time during service, use, or otherwise. Disclosure of sensitive personal data by a corporation to a third party requires the provider's permissions. The body corporate must appoint a grievance officer and post his contact information online. Now, with the Aadhaar judgment, that is of Justice Puttaswamy versus Union of India, it was held that right to privacy is a fundamental right and is protected as a part of the right to life and personal liberty under Article 21 and as part of the freedoms guaranteed by Part 3 of the Constitution. The ruling recognizes both privacy and informational privacy as fundamental rights. It has recognized the need of data regulation and indicated some important aspects of information, including information is not competitive. That is, it can be consumed by multiple users and players. Information, which includes collection, use, storage, and processing, can be invisible, which means that the information provider may not be aware of such activities. And information is recombinant, that is, fragments of information collected from various sources can be combined to form a complete profile. Now, the judgment recognizes that some information warrants privacy and the right to be left alone. The current law, that is Information Technology Act 2000, as amended in 2008, recognizes personal information and personally sensitive data or information and stipulates that any collection or use of such data or information can be done only with the user's explicit consent, and the user should have the choice to provide or not provide such information. The judgment emphasizes transparency in obtaining consent for information collection, use, retention, and processing. Any encroachment on privacy must be through a legislated law, and such law must meet all constitutional requirements when imposing reasonable restrictions on fundamental rights. The court urged the legislature to adopt a data protection regime that balances individual interest and state concerns. Now, after Puttaswamy judgment, MIET formed an expert committee in August 2017 to study key data protection issues and recommend solutions. The 10-member committee was headed by Honorable Mr. Justice B.N. Sri Krishna, a retired judge from Honorable Supreme Court, and involved government and academic and industries members. The committee had to draft a data protection bill, who recommended the Personal Data Protection Bill 2018. The government revised this proposal and tabled it as the PDP Bill 2019 in the Lok Sabha. The Lok Sabha referred the PDP Bill 2019 to a joint parliamentary committee on the same day. However, due to pandemic, the JPC presented its report on the PDP Bill 2019 in 2021. The JPC's proposal were incorporated into the Data Protection Bill. However, the government withdrew the bill in August 2022, citing the JPC's report and substantive revision in the 2019 bill. Now, in the month of November 2022, the Digital Personal Protection Bill was reintroduced for the public consultation. Now, talking about the governing principles around the bill, as given in the explanatory note published by MIET, that the Digital Personal Data Protection Bill outlines the rights and duties of citizens known as digital Nagrik and the data fiduciary obligations to utilize gathered data responsibly. The bill's data economy principles are: organizations must use personal data lawfully, fairly, and transparently. Personal data should only be utilized for the purpose it was gathered. Only personal data needed for a specific reason should be collected. Under accuracy of personal data is maintained accurate and up to date. With regard to the storage limitation, the principle is that personal data isn't automatically saved forever. The data should be stored only as long necessary for the specified purpose. Sufficient precautions to prevent personal data theft or misuse, which avoids information leak. And the last governing principle is that the person who chooses the purpose and means of processing personal data must be accountable. Now, talking about the framework of the bill, it has 6 chapters containing 30 clauses and 1 schedule. Now, the preliminary chapter has 4 clauses which include the definition clause and the application of the act. Now, talking about the definitions, data principle refers to the person to whom personal data belongs. Considering the utility and usage of children's personal data, parents or legal guardians are also referred to as data principles. Personal data means any data that can identify an individual. Data fiduciary is also a term which was being used. It means the individuals, corporation, firm, or state that decides the purpose and means of processing personal data. The word fiduciary emphasizes that the data principle, that is the one who is providing the data, and the data fiduciary, the one who is keeping the data, should have a trusting relationship. The definition of processing covers all personal data operations. According to the bill, processing includes procedures from collection to storage. Public interest has also been defined in the bill for the purpose of clarity. Now, Chapter 2 of the bill speaks about obligations of data fiduciary with 7 clauses. Chapter 3 speaks about rights and duties of data principle with 5 clauses. Chapter 4 speaks about the special provisions with 2 clauses. Chapter 5 is the compliance framework with 7 clauses. Chapter 6 is miscellaneous with 5 clauses. A schedule is also appended with fine penalty. Now, talking about the scope of the data, Clause 4 deals with the application of the proposed legislation. The DPD Bill 2022 covers all digital data processing. This includes online and offline personal data digitized for processing. The bill concerns the processing of personal data gathered by data fiduciaries in India and used to offer products and services in India. About the non-application of the proposed legislation under Clause 4 only, the bill does not cover offline personal data. It also does not cover non-automated processing of personal data. Personal data processed by individual or personal for domestic purposes, and the personal data about an individual contained in a 100-year-old record. Now, personal data processing requirements are explicit. First, personal data must be processed according to the bill. Second, the processing must be legal. Before processing, the personal data can be handled. The individual must either have provided consent or be deemed to have given consent. Protecting personal data starts with understanding how it is processed. Every person should know what kind of personal information a data fiduciary wants to collect, as well as why they want to collect and use that information. This is made possible by the bill's provision about notice. The DPD Bill stipulates the data principles shall be given an itemized notice or request. It has been stated that the notice from the data fiduciary to the data principal should be written in clear, plain language and available in the 8th schedule language. For example, A contacts a bank to open a regular saving account. The bank asks A to furnish photocopies of proof of address and identity for KYC formalities. Before collecting the photocopies, the bank should give notice to A stating that the purpose of obtaining the photocopies is completion of KYC formalities. The notice need not be a separate document. It can be printed in the form used for opening the savings bank account. When the data principal consent is the basis for processing personal data and a challenge arises in the court, the data fiduciary shall be obliged to prove that the data principal was notified and gave consent in line with the Act. Now, continuing with the consent, in several situations, seeking consent of data principal is impracticable or is inadvisable due to pressing concerns. According to the explanatory note, clearly defined situations wherein insisting on consent would be counterproductive have been listed under the deemed consent provision in the bill. What are such scenarios? Voluntary providing the data. If the data principal gives her personal information to the data fiduciary on her own and it is reasonable to expect that she would do so. For example, A shares her name and mobile number with a restaurant. A shall be deemed to have given her consent to the collection of her name and mobile number by the data fiduciary for the purpose of confirming the reservation. For the performance of any function under any law. For the state, that is for the state or any state instrumentality to perform a legal function, provide a service or benefit to the data principal, or issue a certificate, license, or permit for the data principal action or activity. For example, A shares her name, mobile number, and bank account number with the government department for direct credit of agricultural income support. A shall be deemed to have given her consent to the processing of her name, mobile number, and bank account number for the purpose of credit of fertilizer subsidy or order issued under any law. There is a deemed consent also with regard to the compliance with any judgment or order issued under any law. There is also a deemed consent for responding to a medical emergency involving a threat to the life or immediate threat to the health of the data principal or any other individual. Again, it is considered to be a deemed consent where measures are taken to provide medical treatment or health services to any individual during an epidemic, outbreak of disease, or any other threat to the public health. Another scenario of deemed consent is to ensure the safety of or provide assistance or services to any individual during a disaster or breakdown in public order. Deemed consent is also considered for the purpose related to employment, such as preventing corporate espionage, protecting trade secrets, intellectual property, and classified information, recruiting, terminating employment, providing any service or benefit requested by an employee, verifying the attendance and assessing the performance. The illustration given in the bill with regard to this scenario is that A shares her biometric data with her employer B for the purpose of marking A's attendance in the biometric attendance system installed at A's workplace. A shall be deemed to have given her consent to the processing of her biometric data for the purpose of verification of her attendance. Deemed consent is also considered in the public interest, including fraud prevention and detection, mergers, acquisitions, or other similar combinations or corporate restructuring transactions, network and information security, credit scoring, operation of search engines for processing publicly available personal data, processing publicly available personal data, and debt recovery. Or deemed consent is also considered for fair and reasonable purposes that may be set after taking into account whether the legitimate interest of the data fiduciary in processing for that purpose outweigh any negative effect on the rights of the data principal or any public interest in processing for that purpose and the reasonable expectation of the data principal given in the context of the processing. Now, for a person to have a meaningful control over her personal data, the consent should not be permanent and it should not be irrevocable. The bill states that the data principal can change his or her mind at any time and withdraw the consent. Now, the consequences of the withdrawal of the consent are also laid down in the bill, that the data principal may withdraw the consent to process personal data at any time. Such data principal must bear the withdrawal's consequence. Revocation of the consent does not impact the lawfulness of processing based on the consent preceding withdrawal. This withdrawal must be as easy as consent. The illustration given is that, for example, A enters into a contract with B to provide a service X to B. As part of the contract, B consents to processing of her personal data by A. If B withdraws her consent to processing of her personal data, A may stop offering the service X to B. Now, if the data principal withdraws her consent to the processing of personal data, the data fiduciary must cease and cause its data processors to cease processing such data principals personal data within a reasonable period of time, unless such processing without the data principal consent is required or authorized under this act or in any other law. Illustration given is that A subscribes to an email and SMS based sales notification service operated by B. As part of the subscription contract, A shares her personal data, including mobile number and email ID, with B, which shares it further with C, a data processor, for the purpose of sending alerts to A via email and SMS. If A withdraws her consent to the processing of her personal data, B shall stop and cause C to stop processing the personal data of A. Now, the performance of any contract already made between a data fiduciary and the data principal shall not be made dependent on the consent to the processing of any personal data that is not necessary for that purpose. For example, if A enters into a contract with B to provide a service X to B, then A shall not deny to provide service X to B on B's refusal to give consent for collection of additional personal data, which is not necessary for the purpose of providing service X. Now, the bill also speaks about consent manager. Digital economy has significantly expanded the number of companies one interacts with. Consent to personal data processing it is not always easy to track. So in that response, consent managers have emerged. A consent manager platform gives a user a complete view of her interaction with data fiduciary and the consent given. The bill recognizes consent manager. Now the question arises as to, will the consent requirement apply retrospectively to cases where the data was already collected? So the answer to the said question is yes. The DPDP bill states that the requirement to obtain consent will be applied retrospectively. If a data principal consented to the collection of their personal data prior to DPDP bill commencement, then all data fiduciaries would be required to provide a notice to such data principals describing the personal data already collected from them and the purpose for which such personal data was collected. Now, what are the duties and the responsibilities of data fiduciaries under the bill? The DPDP bill lists all the data fiduciary obligations and makes them responsible for processing personal data. A data fiduciary shall make reasonable efforts to ensure that the personal data processed by or on behalf of the data fiduciary is accurate and complete. If the personal data is likely to be used by the data fiduciary to make a decision that affects the data principal to whom the personal data relates, or is likely to be disclosed by the data fiduciary to another data fiduciary. The illustration given is that, for example, A has instructed her mobile service provider B to mail physical copies of monthly bills to her postal address. Upon a change in her postal address, A duly informs B of a new postal address and completes necessary KYC formalities. B should ensure that the postal address of A is updated accurately in its records. Another obligation of data fiduciary is that the data fiduciary shall implement technical and organizational steps to ensure effective compliance. Every data fiduciary and data processor must take appropriate security precautions to prevent personal data breach. If the personal data breach occurs, the data fiduciary or data processor must notify the board and each affected data principal. A data fiduciary must stop retaining personal data or remove the means by which it can be associated with a particular data principal when it is reasonable to assume that the purpose for which the personal data was collected is no longer being served by its retention, and retention is no longer necessary for legal or business purposes. For example, A creates an account on X, a social media platform. As part of the process of creating the account, A shares her personal data with X. After 3 months, A deletes the account. Once A deletes the account, X must stop retaining the personal data of A or remove the means by which the personal data of A can be associated with A. Another example given is that A opens a savings account with the bank. As per KYC formalities, A shares her personal data with the bank. After 6 months, A closes the saving account with the bank. As per KYC rules, the bank is required to retain personal data for a period beyond 6 months. In this case, the bank may retain A's personal data for the period prescribed in the KYC rules because such retention is necessary for the legal purposes. Every data fiduciary must post the contact information of a data protection officer if applicable, or a person who can answer the data principal inquiry regarding her personal data. Every data fiduciary must have a grievance method and mechanism. A data fiduciary may transfer personal data to another data fiduciary or engage, appoint, use, or involve a data processor under a legitimate contract. If approved under its contract with the data fiduciary, data processor may also engage, appoint, use, or involve another data processor in processing personal data. Now, continuing with the responsibilities of data fiduciary with respect to the children, in the explanatory note, it was stated that the children's personal data is a distinct category as they need more protection. The bill prohibits processing of personal data that could harm a child. Parents and guardians have a specific role in children's personal data. A data fiduciary shall not undertake tracking or behavioral monitoring of children or targeting advertising directed at children. Next is about significant data fiduciary. Now, due to consideration like volume of personal data, risk to data principles, etc., certain data fiduciaries must have additional responsibilities in the interest of data principles. The bill mentions significant data fiduciary. This group must meet additional obligations for higher scrutiny. The significant data fiduciary must select an India-based data protection officer to represent it under the Act. The data protection officer reports to the significant data fiduciary's board of directors or equivalent. The data protection officer shall be the point of contact for the grievance redressal mechanism under the Act. The data protection officer shall appoint an independent data auditor to evaluate the significant data fiduciaries' compliance with this Act and take such measures, including data protection impact assessment and periodic audit as may be prescribed. So these are some of the duties of the significant data fiduciary who shall be nominated, who shall be notified by the central government. Now coming to the rights and duties of the data principal, that is the information provider. Now the first right is right to information about personal information. Now everyone should have access to the fundamental personal data. The right to information includes confirmation of processing, a summary of personal data, and disclosure of data of fiduciaries with whom the data has been shared. Another right consists of the data principle is the right to correction and erasure of personal data. Now, sometimes personal data must be changed, such as when moving to a new city, personal data may have been collected incorrectly. The bill includes right to correct, right to update, right to complete, and right to erase personal data when no longer needed. The data principal has also got the right for his grievance redressal. The bill specifies the right to make a complaint with the data fiduciary and the grievance with the data protection board if neither responds. There is also a right to nominate. Nomination is a core practice and right in financial services. Learning from this experience, as explained in the explanatory note, the bill includes the ability to nominate personal data. How about the duties of the data principal? A data principal must follow all applicable laws when exercising rights. Data principal shall not file false or frivolous complaints with data fiduciaries or board. The data principal shall not provide incorrect information or impersonate another person while applying for a document, service, unique identifier, proof of identity, or proof of address. A data principal shall only correct or delete the verifiable authentic data. Now let's talk about the special provisions that have been incorporated in the bill. The first provision is with regard to the transfer of data outside India. Now, globalization is characterized by cross-border exchange. The bill allows a personal data transfer to certain specified countries and territories. The central government assessment would precede a notification. Also, acknowledging national and public interest is at times greater than the interest of the individual. So a description of exemptions has been incorporated in the bill. Now let's talk about the compliance framework. Now, there will be a Data Protection Board of India. So far, the Constitution and the function of the Data Protection Board is concerned. The Data Protection Board is a body tasked with the enforcement of provisions of this Act. A digital by design compliance framework is the need of the hour, particularly when it comes to a digital personal data. This has been recognized in the bill. From receipt of the complaints to the pronouncement of a decision, it has been clearly envisaged as digital by design in the bill. So far, the judicial powers are concerned of the Data Protection Board. Adherence with the principle of natural justice at every stage in a proceeding has been clearly mentioned as required in the end-to-end process or of inquiry as per the explanatory note. Also, if the board believes a complaint may be better resolved by mediation or any other procedure, it may direct the parties to try to resolve the disagreement through mediation by a body or a group of persons chosen by the board or such other process as the board may see fit. It also talks about voluntary undertaking. Voluntary undertaking has been included as a measure to encourage timely admission and rectification of lapses. According to the explanatory note, this would go a long way in establishing clear focus on enabling and facilitating compliance rather than penalizing non-compliance. In the compliance framework, it also talks about the financial penalty. That financial penalty has been prescribed as a deterrent for non-compliance. Criminalization of lapses and non-compliance has been avoided. Subject matter of non-compliance and penalty has been provided in the schedule. DPDP bill penalties range from rupees 10,000 to 250 crores. The DPDP bill also lists factors to consider when determining the penalties. Then there is a last chapter which deals with the miscellaneous provisions. Now, according to the explanatory note, the power of central government is there to make rules, remove difficulties in implementation of the bill, and it has got limited power to amend schedule, which has been separately listed. The intent is to provide for general law that applies horizontally across sectors while allowing the scope for sector-specific legislation. This has been clearly provided by stating that the provisions of this bill will not be over and above provisions of other acts except to the extent of conflict with the provisions of the bill. As it has been given in the explanatory note, which was also published along with the bill. Now, talking about the current status of the bill, this bill is available on the official website of meati.gov.in. Along with the bill is also present the explanatory note explaining the intent behind the provisions given in the bill. Apart from that, the ministry has also invited feedback from the public on the draft bill. The submissions will not be disclosed and held in fiduciary capacity to enable persons submitting feedback to provide the same freely. According to the official notification, no public disclosure of the submissions will be made. The feedback on the draft bill in a chapter-wise manner may be submitted on this given address by 17th of December 2022. So the bill is yet to be tabled before the Parliament. So let's wait as to how it comes across for us. This brings to an end of our another session. We'll meet again with some new topic in our next presentation. Till then, namaskar.